One thing that I see continually in DUI cases that absolutely is preventable, that's absolutely ridiculous that any lawyer would do, but that people obviously are continuously doing this, is they're making agreements at the administrative license suspension hearing for their clients to plead guilty in a breath test case. There is absolutely no reason to do that. All that it takes is a little bit of communication between the lawyer and the client so that the client understands that this is a suspension with a limited permit for 30 days, and then they're fully eligible for reinstatement of their license if they complete a DUI school and pay a reinstatement fee. They'll also get credit for that time towards any suspension if they're ultimately convicted in the DUI case. What I see is that the lawyers are now, after Elliott, the vast majority of breath tests are being suppressed, excluded from evidence by the trial courts. And then you'll have the solicitor, the prosecutor, who comes back and says, well, I still want to try to introduce evidence of the agreement to plead guilty from the ALS. It's just a whole confusing mess that was completely preventable, that never should have happened in the first place. I mean, there's no reason at all to enter into that sort of agreement in a breath test case. The only case in which an agreement is possible that you should really consider it is in a refusal case, and that's because you face the possibility of a hard license suspension with no limited permit whatsoever for 12 months. If you're in that situation, I can understand then a lawyer advising their client to negotiate for a guilty plea at the ALS hearing so that they can save their license. But if you're in a breath test case, particularly a first lifetime DUI breath test case, there's no reason at all why you should be entering into that agreement. Almost every lawyer who actually defends DUI cases would tell you that if you've got a breath test, with a really experienced officer, the vast majority of them are just going to withdraw that suspension. And that's because it's not worth the time, the effort to go through an hour hearing in the administrative license suspension just to have that sort of suspension imposed with a limited permit for 30 days and then full reinstatement. It's just generally not worth it. And then second, if you do have to actually go through the hearing, it's usually helpful to you. You learn a lot about the officer, you learn a lot about their case, and you learn it prior to the criminal case even being initiated. So if you are a client and you have your lawyer has entered into that sort of agreement or advised you to enter into that sort of agreement, really reconsider whether or not that person is competent to handle your case. That is not the sort of agreement that a person who really understands what's going on in these cases would enter into. Second, if you're a lawyer who's doing that, who's entering into those sort of agreements at the administrative license suspension hearing in breath test cases, don't do it anymore. Really reconsider your course of action because strategically it just doesn't make any sense at all. If you have any questions about these issues, feel free to call me. My name is Ben Sessions. My phone number is 470-225-7710. Again, 470-225-7710. Thank you.